All right, good morning, everybody. It is July 28th and it's 9:30, and this is the Colorado Oil and Gas Commission weekly meeting. We will start with a roll call of commissioners.
Thank you, Mr. Chair. Commissioner Bogue,
Here.
Commissioner Gonzalez,
Here.
Commissioner Hackett,
Here.
Commissioner McGowan,
Here.
Commissioner Mesner,
Here.
Commissioner Nanjapa,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 7 out of 7 commissioners present.
Great to see everybody. Great to be with everyone virtually yet again. We have a fairly short agenda today. We are going to take public comment, director report, information on a spacing order from Great Western, consent agenda, and then commissioner comments. So we will start with public comment. It is a normal Wednesday meeting. We give 3 minutes per public commenter. We also ask folks to sign up ahead of time by noon as of yesterday. From the discussions that I've had with our public commenters, everybody suggests that this is working fairly well. So with that, I would turn to Hearings Manager Larson to help us facilitate through the public comment that we have this morning.
Thank you, Mr. Chair. First up, we have Tess Dougherty. We'll bring Ms. Dougherty in as a panelist and begin her time when she's in.
Hi, Commissioners. Good morning. Thank you for allowing us this time to speak. I want to acknowledge that we reside on the occupied land of the Arapaho, Ute, and the Cheyenne, and 48 other tribes who still pass through and utilize this land today. I am going to play a video that won a short film showcase for National Geographic a few years ago, and I'm only going to be able to play half of it today, but I can play the other half and I can send it to y'all. So here we go.
Fun fact, planet Earth is 4.5 billion years old. Mankind, about 140,000 years old. Let me put that in perspective. If you condense the Earth's lifespan into 24 hours, that's one full day, then we have been here on this planet for, drum roll please, 3 seconds. 3 seconds. And look what we've done. We have modestly named ourselves Homo sapiens, meaning wise man. But is man really so wise? Smart, yes, and it's good to be smart, but not too smart for your own good. Yes, we have split the atom. Yes, we build clever machines that navigate the universe in search of new homes, but at the same time, those atoms we split created nuclear warfare. In our quest to explore the galaxy, rejects and neglects the home that we have here now, so no, that cannot be wisdom. Wisdom is different. While intelligence speaks, wisdom listens. We willingly covered our ears to Mother Nature's screams and closed our eyes to all of her help-wanted signs. Wisdom knows that every action has an equal and opposite reaction, so if we were wise, we would not be shocked when we see storms that are stronger than ever before, or more drought, hurricanes, and wildfire than ever before, because there's more pollution than ever before, more carbon, more trees cut down than ever before. At a record pace, we have increased the extinction of animals by 1,000 times the normal rate. What a feat. In the next 10 to 100 years, every beloved animal character in every children's book is predicted to go extinct. Lions gone, rhinos gone, tiger, gorilla, elephant, polar bear gone. In 3 seconds. Species that have been here longer than us will be gone because of us. In this 3 seconds. In an existence shorter than a Vine video, we turn the circle of life into our own personal conveyor belt. Somebody, anybody help. We were given so much. The only planet in this solar system with life. I mean, we are 1 in a million. No, actually, scientifically, we are 1 in a billion, trillion. That's a 1 followed by 33 zeros. And I don't want to get too spiritual, but how are we not a miracle? We are perfectly positioned to the sun, so we don't burn, but not too distant, so we don't turn to ice. Goldilocks said it best.
Ms. Dougherty, thank you. Your time has expired.
Thank you.
Next up, Mr. Chair, we have Kate Christensen. Give us a moment and we will bring Ms. Christensen in.
Hello. Thanks for hearing my comments today. The Denver Business Journal a couple weeks ago reported that there are many oil and gas companies in talks with the COGCC about landscape level plans. For example, they reported that that PDC Energy is proposing 457 wells across 51 square miles of Weld County. I understand from the reporting they're looking at electrification and pipelines instead of trucks. But even with those modifications to the drilling process, the scale and scope of this project does not align with public health, safety, and the environment, and therefore it doesn't align with current law. There are two reasons why this doesn't align, or at least two that I can think of right now. The first is air quality. Colorado has had an F- air quality from the American Lung Association for over a decade. The oil and gas industry contributes to about half of that air pollution. The area where these wells will be drilled is in an EPA ozone non-attainment area. Neither of these things are conducive to public health. The second piece is water. The USGS says that water use per well can be anywhere from 1.5 million gallons to 16 million gallons. So let's lowball it and say 5 million gallons on average. That means that just this landscape plan that PDC Energy is proposing would use 2,500,000,000 gallons of water. We are in a drought. Summers are getting hotter. Fire seasons are getting worse. We need that water, not for fracking, but for crops and for fighting fires. The Greeley Tribune reported last week how tough it is for farmers in Weld County because of climate change. And the oil and gas wells are direct contributors to climate change. So it's just going to make it worse. In the conversations I've had with commissioners, I get the sense that there's this pervasive feeling of, well, we can't just tell oil and gas companies they can't drill. You can though. Before years ago, that was totally true. Before SB 181, the Oil and Gas Act defined waste as fossil fuel left in the ground. Senate Bill 19-181 revised that definition of waste. The General Assembly added a clause to the definition specifying that waste, I'm going to quote here, does not include non-production of oil and gas from a formation if necessary to protect public health, safety, welfare, the environment, or wildlife resources as determined by the commission. I know this is a huge shift. I know you guys all went through mission change rulemaking, all the things, but as these Form 2As start coming in, please remember that you can tell oil and gas companies no, that legally you should. We have to leave some of it in the ground to protect the people of Colorado. We need to do it to protect our air, to preserve some water, to protect our health. So 10 seconds left. Thanks for your time.
Thank you, Ms. Christensen. Next up, Mr. Chair, we have Shayna Oliver.
Hi, can you hear me? Hello?
Yes, we can hear you.
Ms. Oliver.
Okay, thank you. I just want to say that Moms Clean Air Force Colorado chapter acknowledges the stolen lands of over 574 tribes nationally, and that we sit directly on the lands of the Cheyenne, Arapaho, and Ute nations and 45 other tribes that once occupied Colorado. My name is Shayna Oliver, and I'm a Northeast community member of Denver, an organizer for Eco Madres and Moms Clean Air Force in Colorado. It's the organization of moms, dads, and caregivers fighting for all children's right to breathe and play in clean air. And also, as being an Indigenous people's rights advocate, most importantly, I am a mother of 4, and my family are the descendants of the genocide known as the Indian Removal Act, known to the Diné as the Long Walk of the Navajo. So these policies continue to violate Indigenous communities' health, wealth, and environmental well-being. And seeing the devastation on Indigenous people's lands and the health impacts on our people, it continues to this day. And as well as this community in Commerce City, north of Denver and North Denver, these same communities are still being impacted with these same impacts of having low birth weight babies and being diagnosed with asthma. And these community members are being diagnosed with cancer, brain cancer, stomach cancer. If you go knock on the doors of these communities, you will hear their stories of what they're being impacted with already from an industry that exists in their backyards. And you continue to systemically pursue environmental violence and racism and built into these policies, and you continue to perpetuate these same practices on these same communities, impacting these same communities by allowing oil and gas to be right next door to our communities. Many people are moving here thinking that they're going to move in a safe place where they can experience the great outdoors recreation, the beautiful mountains, the blue skies. But when they get here and they're moved to these communities where that's not true, and there is no more blue skies, now it's brown skies, which we've been experiencing poor ozone air quality, like on a record straight level, that we continue to have these poor air quality days that are being impacted on ozone and on ozone pollution, which is predominantly impacted by oil and gas industry, are like a big contributor to ozone pollution. And you should know that. And you should know that you know how to protect communities, you know how to protect children from these industries.
Ms.
I
Oliver, I
say
apologize.
no.
Your time has expired.
And putting more and asking more from these industries.
Ms.
There
Oliver,
should be
we
a
are going to have to
$230,000
wrap up.
per well insurance, and not a frivolous amount of like a couple $100.
Thank you, Ms. Oliver. We're going to
So
move on to our next.
Don't leave
speaker.
this on the
Appreciate it.
taxpayers.
Ms. Oliver, your time has expired. Thank you.
Next up, we have Ed Ingve.
There we go. Now I think I'm live, right?
We can hear you and we can see you, Mr. Ingve.
Okay. I'm going to take my wrath a little bit differently today, but my name is Ed Ingve. I'm owner operator of Renegade Oil and Gas Company. Been operating in Colorado for 35 years, predominantly small little stripper wells, some of which were drilled as stripper wells and have been good wells for me. They've never been anything but a stripper well. But anyway, my son's going to kill me, but my son, along with hundreds of other young Colorado Guardsmen, are currently deployed in the Middle East. He's part of the 1st Battalion, 157th Infantry Regiment as part of Task Force Iron Gray by Governor Polis's signature. Their mission is to fight terrorism and to protect the free, unencumbered flow of global oil supplies, ensuring international economic security. That's right. The governor can commit hundreds of Colorado citizens to protect dirty barrels coming from the Middle East while doing everything he can to undermine the production of the greenest barrel on the planet here in Colorado. How the heck do I reconcile this? Am I supposed to be sympathetic because Mr. Polis was upset that somebody drilled close to his guest house across from his large Boulder County estate? It's frustrating. I'd like to ask you, though, how does Senate Bill 181 protect the public health, safety, welfare, and environment of the Colorado soldiers being deployed and their families? There's hundreds of them. What consideration are you giving to these Colorado citizens when you consider adoption of any of these new rules? I suggest, and I think it is none. That's shameful. I hear a lot about you talking about your support for all different things, you know, whether it be Trout Unlimited, Outward Bound, the Democratic Party, Great Outdoors Colorado, amphibians and reptiles conservation, and even the BLM movement. But I don't ever hear you standing up for these Colorado citizens. There's hundreds of Colorado citizens. I'm not talking about the regular military. I'm talking about the guardsmen. The Colorado National Guard is in the Middle East protecting oil supplies. Certainly, I don't want to hear you guys ever say that you are supporting rural communities with what you're doing. I don't want to hear you say how you're supporting Colorado small businesses, because you're not. And I certainly don't ever want to hear you guys say you are supporting our troops and thank you for their service, because you are not. Good day.
Next up, Mr. Chair, we have Brad Clyfen. Give us one moment and we will bring Mr. Clyfen in.
Am I live, I guess?
Yes, we can hear you, Mr. Clayton.
All right, thank you, commissioners. As you know, next week, the public comment periods will be ending on a couple of new Form 2A applications. And I have a few questions about that process that I hope I can get a response to. Will all comments be responded to in writing by staff? Will staff issue a written decision on the application detailing the project terms and stipulations which will be imposed? Will that be distributed to commenters and/or the general public? After staff approves a permit, how long will the public have to object? Will the commission automatically review Form 2A applications? Or will it take a formal hearings appeal by citizens to get the commission to look at the applications? Will citizens need lawyers for such an appeal? Will the commission view affected person, the term affected person, narrowly as in federal cases or with a wider meaning? Will organizations with subject focus, such as wildlife and plants, etc., be considered affected persons? Or will we need to identify specific members who will be affected? As we go forward in this whole process, I just think that there's not a lot of information that the public has on the procedural parts of this. And if you could clarify that in the next week or so, that would be greatly appreciated. I'll sign off now in hopes that I can get a response in my remaining minute. Thank you.
Thank you, Mr. Clayton. We have published quite a bit of guidance on our website for stakeholders so that they can become familiar with how to participate in our process. I also would direct you to Hearings Manager Larson or Director Murphy. If you wanted to email specific questions about participation, we can make sure that someone from staff will get back to you. Thank you for your time this morning.
All right, I'd appreciate that. Thank you very much.
Thank you, Mr. Chair. Next up, we have Marie Venner.
Hello, Commissioners. I am here speaking from the Small Business Alliance. Many of our members and my family background is in rural areas. I want to re-emphasize points of previous weeks that full cash bonds and full coverage are needed for financial assurances, not blanket bonding, which does not work and leaves Coloradans exposed. North Dakota has figured this out. Colorado needs to as well. I hope our comments from the last couple of weeks have been noted and are heeded. As you know, an important report is due out. In the words of the UN lead, the decisions nations make in the next few months and the decisions you make in the next few months will likely determine whether we will or will not limit global temperature rise to 1.5 C, which is absolutely critical for Colorado. The top scientists from every country are meeting this week to detail how important this is. As you know, the last edition of this report came out in 2013, but now, even with just 1 degree of temperature rise, we're already seeing 109-degree temperatures in Montana and over 120 in Western Canada. Colorado's future is at risk. Key life support systems, including our temperature, agriculture, and food production systems, again, speaking from an ag family background, all of this is at risk. The 2015 Paris Agreement was signed by almost every nation and agreed to keep temperature rise to 1.5 C. So, going up again half as much as we've already seen, at very great risk to ag in our state and our fundamental industries here. 2 months ago, the International Energy Agency warned that existing coal and gas operations must be shut down as quickly as possible for the world to have a chance of meeting these, what has been agreed to internationally. And the reality is that we are not on track to achieve these important goals and our own statutory commitments in Colorado. In fact, we're on the opposite track. Patricia Espinoza, Executive Secretary of the framework, said, and it's important that COGCC stop being part of the problem. We are relying on you as Colorado's small businesses and families to do the right thing here, to provide full coverage with the financial assurances from all existing well owners. Thanks. Oh, and the amount of money spent on Afghanistan and Iraq is about the same amount as it would cost to fully transition our energy system. We had a presentation.
Ms. Venner, your time has expired.
This last week. Thanks.
Next up, we have David Hagan. Mr. Hagan, are you coming in under Ms. Dougherty's Zoom account?
Yes, he is. 1 second. Okay. He just wants me to play this, to finish playing this. So I'll just go ahead and do that.
This paradise where we are given medicine from trees, not coincidentally, but because like the song says, we are family, literally. Every species is connected genetically from the sunflower to the sunfish. And this is what we must recognize before it's too late, because the real crisis is not global warming, environmental destruction, or animal agriculture. It is us. These problems are symptoms of us, byproducts of us. Our inner reflection, loss of connection has created this misdirection. We have forgotten that everything contributes to the perfection of Mother Nature. Corporations keep us unaware and disconnected, but they have underestimated our strength. Contrary to popular belief, millions are waking up out of their sleep, seeing our home being taken right up under our feet. We cannot allow our history to be written by the wicked, greedy, and gloomy. It is our duty to protect Mother Nature from those who refuse to see her beauty. Call me crazy, but I believe we should have the right to eat food that's safe, with ingredients we can pronounce, drink water that is clean, marvel at trees, breathe air free of toxins. These are natural rights, not things that can be bargained for in Congress. powers. See, they want you to feel powerless, but it has been said that something as small as the flutter of a butterfly's wing can cause a typhoon halfway around the world. But when enough people come together, we too will make waves and watch the world into a new era filled with love and connection, freedom for all without oppression. But it is up to you, yes, you watching this behind this screen, to make the effort, because time is of the essence, and only together can we make it to the fourth second.
Thank you.
Thank you, Ms. Dougherty. Mr. Chair, we do not have any other individuals signed up to provide public comment today.
Okay, good. Thank you. Thanks for the folks that joined us for public comment. We made it through the entire list and we do not have any no-shows. I would note for the record that we did receive 2 written public comments, one from Emily Roller and a written comment from Patty Sullivan, which the commissioners have reviewed. We appreciate folks providing written comments as well. As has been past practice over the last few weeks, wanted to see if any commissioner has any comments to the public comment or responses to public comment at this time before we move on with our agenda. Commissioner Hackett.
Thank you, Mr. Chair, and thank you to all the public commenters for taking the time with us today. Just wanted to make sure folks were aware of an upcoming stakeholder meeting over at CDPHE at the Air Pollution Control Division. There were a lot of comments about greenhouse gas emissions, so just wanted to make sure folks were tuned into that process. Earlier this week on Monday, the Air Pollution Control Division did release draft rule language for their oil and gas greenhouse gas rulemaking effort. My understanding is that this first draft of rules is focused on the midstream sector, and then they'll be holding a stakeholder meeting on August 16th from 2 to 4 to get feedback on those rules. And I'm going to go ahead and post in the chats the website where folks can find that rule language and where they can find the registration link to attend that meeting. And that's all I had.
Thank you very much, Mr. Hackett. Thanks for keeping us apprised of the work that's going on with our sister agency on the greenhouse gas rulemaking. And folks can see the link if you want to sign up for that in chat. I'm not seeing any further response to public comment from commissioners at this time. And with that being the case, we will move on to hear from Director Murphy if she has a report. I don't know, I didn't check in earlier, so putting you on the spot, apologize for that. Do you have anything you'd like to report to us?
I have a couple very quick updates, if I may, Chair. First and foremost, we're continuing to work on supporting implementation of the mission change rules with in meetings with stakeholders, partners, staff, etc. As everybody knows, the financial assurance rulemaking is ongoing, and we did reopen the opportunity for people to file party status. And I think we're expecting a new case management order. One of the places that I did want to provide a slightly more robust update is on the implementation of Senate Bill 21264. This included a specific directive to staff, to COGCC, to prepare a report by December 1st, 2021 about the implementation of carbon sequestration. And it's kind of in the framework of EPA's Class 6 underground injection control well program for carbon sequestration. I wanted to report out that we have identified an internal staff member who has taken on that responsibility. It's his sole job function right now. We're meeting with a diverse group of stakeholders who have expertise in this arena to try to glean information from them that has already been developed, and that includes meeting with other regulatory agencies, including EPA, ENGOs, industry partners. So wanting to make sure we understand what information has already been developed. This is a robust and interesting topic, and I know conversations about carbon sequestration and modeling in particular are occurring at the federal level as well. So I'm trying to make sure we don't reinvent the wheels, a long-winded way of saying we're meeting with a bunch of folks to understand the literature that's already out there and then provide a Colorado-specific focus. In that process, we're also partnering with the Carbon CCUS task force that I think was established through legislation in 2019, maybe it was 2020, to again, make sure we're working in tandem with that process and not reinventing or complicating it. It's a really exciting, dynamic, interesting opportunity for the state of Colorado. We're appreciative of the opportunity to explore it, but wanted to update all of our stakeholders and each of you that that work is ongoing. And if folks have questions or want to engage or discuss it, please don't hesitate to reach out to me right now. I'm working closely with our staff on it and our external partners. So that's a long-winded report on Senate Bill 21264. We'll look forward to getting that finalized report out by December 1st. Any questions? Should I break there before I jump topics, Chair? I felt like you might have leaned forward like you wanted to talk to me.
No, go ahead.
Okay, great. Body language over Zoom still is a learning process for me. The other update I wanted to provide is that via DNR's Division of Water Resources, also referred to as the State Engineer's Office, or DWR or SEO, depending on which nomenclature you prefer, received a request to update a 2017 report regarding the use of water in Colorado for hydraulic fracturing. We received that request, I would say 6 weeks ago. We've been working closely with the Department of Natural Resources and their new water liaison, Kelly, as well as DWR leadership to update that for 2021 numbers or for 2021 report. The 2017 report showed an average of 13,000 acre feet per year was used for hydraulic fracturing from 2010 through 2015, which was approximately 0.09% of the water diverted for use in Colorado. The updated report shows that for hydraulic fracturing has increased to 26,000 acre feet, or 0.17% of the water diverted for use. The average annual well completions has declined to 1,100 wells compared to a high of 3,200 wells in 2011. So there are some interesting changes going on. That report is available on our website. I can send that to commissioners as well. My last update is about our website itself. In an effort to reduce or minimize the number of clicks it takes to access hearings information in the Senate Bill 19-181 pages, we made some changes. We moved and consolidated the hearings information on our website and added a new menu tab for hearings that contains all of the hearings related content, including meeting schedules, agendas, recordings, rulemakings, and helpful guidance for using e-filing system, which is, I know, a place we get lots of questions. And the mission change operator guidance, which is associated with implementing the Senate Bill 181 rulemakings, can now be found under regulation following to operator guidance. And all of this information is on our news and notices, but folks may need to clear your web browser cache to see these changes. Delete your browsing history, those kinds of things are very helpful, and then reopening your browser. If you have questions or issues with that, I think Hannah Hickam might be the best point of contact for the kind of how do we find these documents, or maybe Mimi Larson. So those are, again, we're trying to consolidate and make real-time changes to the volume of information that's on our website to try to simplify how people can access it. Because again, there's a huge volume there, but making sure you get to it quickly is really important for our stakeholders. So those are my sum total of my updates. And I'm happy to take questions or talk about other things.
Thank you, Director Murphy. A couple of questions going sequentially from the last part that you just spoke about with regard to updates to the website. And I don't want to put you or staff on the spot, but it might be helpful on a Wednesday meeting to get a brief 5-minute, 10-minute tutorial. Have someone share a screen with our new website and sort of walk us through it, walk our stakeholders through what the new website looks like, or how one can access the information. So if you want to think about that, that would be great. We could do that at one of our Wednesday meetings. Other point, back to the water report or water usage report, you meant that is online, is that right?
I believe so. I'm double
It will
check.
be online. We'll make sure that it's online. I just know that there's always a lot of vigorous dialogue, discussion, debate about water usage with regard to fracking. And so I just wanted to ask you a question. It seemed like that you said that it was a fairly low percentage of the total amount of water diverted for use. Can you describe for our stakeholders and for me, because I don't understand it, what water diverted for use, like what is the sum total of water diverted for use? What is that referencing? And then sort of maybe go back and speak to the percent that's for hydraulic fracturing versus other water diverted for use.
I can very briefly touch on it. So as I understand it, water diverted for use is literally water that we citizens or in industry, and when I say industry, I don't mean oil and gas industry, I mean all of the industrial operations across Colorado, all of the ag.
Right?
Right.
Because ag's huge, I know.
Ag is a pretty significant user of diverted water. And so the state engineer's office or DWR track that information and track water use and making sure it's in compliance with what a water user is allocated to use. And I hope maybe Scott Cuthbertson's listening. We hired him away from DWR. And so his depth of knowledge in this arena is much more substantial than mine. I think the report does a good job of laying out what the different water user categories are in Colorado, from ag to, again, industrial, municipal, et cetera. And again, if we look at the statewide total of water diverted for use in Colorado, 0.17% of it is used in hydraulic fracturing operations.
So Director Murphy, I'm looking at our panelist and it doesn't appear that Scott is with us. That might be another good 5 to 10 minute information session for commissioners and staff. And I appreciate you bringing it to our attention today, but why don't we task Mr. Cuthbertson with presenting us just a teeny bit of information about that report at a later hearing.
Can I suggest, I know Commissioner Mesner has been convening kind of a conversation about water in Colorado. And I think that this would fold nicely into that conversation if that works, and we can have kind of a more cohesive dialogue. And Commissioner Mesner, if I've overstepped in terms of suggesting that, jump in, and we'll make whatever you all want to work.
Commissioner Messner.
Thank you, Mr. Chair. No, that was actually the intent for this water presentation. The informational kind of continuing education piece was to include some information and speakers from the state speaking specifically about water use, and then also some experts presenting on water reuse and other beneficial uses of produced water. And so it should be a pretty all-encompassing conversation, but water use is certainly one of those topics.
That'd be great. Again, didn't mean to get out ahead of my surfboard here, but that sounds great. So John, we'll look forward to that information session on water use in general, and this can be a component of it. So that sounds great. Do we have other questions for Director Murphy? Great. Thank you, Director Murphy, for the report. With that, we will move onward into our agenda. I believe the next matter that we have on the docket is Great Western Operating Company, docket number 2104-00041. And I'm not sure if, I believe this was the matter that was on the agenda last week, and we had some questions about it. And I believe we've got a short presentation from the applicant. And I see that Ms. Wazelinski, the applicant's attorney, is with us. So Ms. Larson, are we turning to the applicant? Does staff have any presentation, or where do we go from here?
Thank you, Mr. Chair. We will be turning to Ms. Wazelinski first. She will be providing information in response to Commissioner Nanjapa's questions from last week. And if there are any additional questions that commissioners may have for staff, we're happy to answer them. But we will begin with the applicant's counsel on this matter.
Great. Good morning. Thank you all. I'm going to share a screen. So if you don't mind just giving me one moment. Let me just start this. Great. Can you all see my screen?
We can.
Wonderful. Well, my name's Kelsey Waselinki. I'm with Jost Energy Law here on behalf of Great Western. With me remotely on Zoom is Santiago Rodriguez. He's a senior landman with Great Western, and Ty Woodworth, who's a district engineering manager with Great Western. And they're here and happy to answer questions. I thought it would be helpful if I just kind of quickly walked through the questions that came up last week, a little bit of an overview of the application, and then we do have an update on the shut-in abandoned wells within the application lands that were cited in the recommended order. So as we know, this docket 2104-00041 is seeking to establish an 800-acre wellbore spacing unit. It's for one well, the Kodak South, we'll call it the 381 HNX well. The Form 2A is approved for this well, and that's why no oil and gas development plan is required. And then Rule 305A2 is the rule that does require that any drilling and spacing unit application contain information of all existing oil and gas locations and associated wells and what the operator intends to do with them. So that is why the subject language was included in Great Western's application and then again in the recommended order. So I just wanted to highlight the language in the application itself. And these paragraph references are different than the recommended order, but paragraph 28 in the application cites a few shut-in or abandoned directional wells. And I highlighted those 3 location IDs. That's 333-268, 333-033, and 333-026. And I'm going to talk about those locations and I'll show them to you on a map here in a couple slides. Within the application, Great Western stated that Great Western does not intend to produce those wells drilled from the 2 Great Western pads. And then paragraph 29 cited an additional abandoned directional wells, and that was on location 333028. And again, within the application, Great Western stated that it does not intend to produce the wells drilled from that Great Western pad. So here's the recommended order language that I believe Commissioner Nanjapa cited last week's hearing. It's paragraphs 26 and 27 in the recommended order are the only paragraphs in this docket that talk about shut-in or abandoned wells. And I'll let you look at this language, but it's essentially very similar to the hearing application where we cite several location IDs, that there are shut-in or abandoned wells associated with those pads, and that Great Western does not intend to produce those wells. This is a reference map coming from the application. My next slide will have a more detailed map, but just to give you an idea of what we're talking about, this is the 800-acre wellbore spacing unit, drilling and spacing unit, but because it's for a single well, we'll call it a wellbore spacing unit. And you can see kind of these circles within the unit will show the status of the locations. If they're yellow, they would have an active well on them. If they're kind of just a white color with an X through them, then that means they're either shut in or abandoned completely. So I'm sort of going to cross-reference this slide with my next slide. And I've circled the locations that we've highlighted within the application that are in the recommended order. And then the next slide will go into detail about the status of each of those locations. So moving from left to right across this map, the first circle is a completely abandoned location. It was never drilled. It wasn't cited in the application or the recommended order because it's not an existing location. It was fully abandoned, never developed. Moving to the right just slightly is Kerr-McGee's pad. This was cited within the application, but because these are not Great Western's wells, Great Western cannot speak for what Kerr-McGee intends to do with the wells. I believe there's just one well producing from that pad location. And then towards the middle is Great Western's location 333033. And then moving to the right, we have 333026, 333028. These are the 3 pads that do have now abandoned wells. And I'll go into detail about the status of each of those wells. And then the far right pad, that's the Kodak South pad. That's an active location. And the proposed well will be drilled from that approved pad location. So this slide shows the kind of more detailed status of each of these locations. And I'm happy to go back to the map if it's easier for you to see that. But location 333033 has been completely closed. So there were 5 Great Western wells on that pad. They have all been plugged and abandoned. Location 333026, the commission records actually show that 2 wells have been plugged and abandoned and 3 wells have been temporarily abandoned. However, Great Western has confirmed that those 3 TA wells have actually been plugged and abandoned, meaning cut and capped as of April of 2021. It's just that there's somewhat of a lag of the Form 6 approval at the commission level, and therefore they're still shown as TA on the map, but they have been fully abandoned. And I've got the dates of those 3 wells, or the specific names of those 3 wells, all P&A'd in April of this year. And then location 333028 is completely closed. There's 3 Great Western wells that have been fully plugged and abandoned. And then the last location I mentioned, this is Kerr-McGee's Pooter pad. It was not referenced in the recommended order. It's not a Great Western location. There is 1 well producing on that location, and so it is still considered active. So that concludes our presentation. I have Santiago and Ty here who are willing and able to answer questions. I'm happy to kind of stay on this slide if that's helpful, but let us know if you have any other questions on this application.
Thank you, Ms. Weslinski, for the presentation. Looking to my fellow commissioners to see if there are questions. Well, you must have done a good job with your presentation. I'm not seeing any questions. So thank you again for developing up the additional information for us as we consider this request.
You're welcome. Thank you for your time.
Okay, then with that presentation, Hearings Manager Larson, are we now, or AG Davenport, do we now need to make a motion to approve docket number 2104-00041?
We do indeed, Mr. Chair. It was not approved at last week's.
Right, because we
commission
pulled it
hearing.
off consent. So
That is correct.
looking to my fellow commissioners to see if we have a motion. Commissioner Messner?
Mr. Chair, I'll move approval of docket number 2104-00041.
Second.
Great. We have a motion. We have a second. Is there further discussion on the motion? Seeing none, all those in favor of the motion indicate by saying aye. Aye.
Aye.
Motion, any opposed? Seeing none, motion carries. Very good. We will continue forward with our agenda. Next on the agenda was a contemplated break, but it was also contemplated we'd be at about 11:15 now. The only thing that we have left on the agenda is consent agenda and then commissioner comments. So I would suggest we move forward. I know some of us have hard breaks at around 11:30, so let's continue. We now have before us the consent agenda. Do any commissioners have questions on the consent agenda? Commissioner McGowan.
Thank you, Mr. Chair. Not a question, but just a comment. I did ask Director Murphy earlier this week if the information about the wells that get plugged and abandoned and reclaimed through the extraction notice will become part of the data that we put together to try to figure out, you know, the average cost for P&A wells. And she said that would occur. So I didn't know if other commissioners had a question about that, but I had that clarified.
Great, thank you for the clarification. Commissioner Messner.
Thank you, Mr. Chair. Just so I'm clear, I mean, I do have questions about the recommended order. that involves extraction. I'm not sure that that is on the consent agenda as a recommended order. I'm happy to make a motion for approval of the consent agenda, but I do have questions about the recommended orders. So however you'd like to handle that, Mr. Chair.
Yeah, I think we can move forward with consent agenda approval, and then we can then have discussion around recommended order. And just for everybody else's sake, recommended orders are not on the agenda. They are part of our portfolio. There are recommended orders from hearing officers. If we decide that we want to act on one of them, pull one of them, talk about one of them, we can do that. If we don't, the recommended orders become an order of the commission. So why don't we move forward with if we've got a motion to approve consent, let's do that. And then we can then talk about the recommended order.
So, Mr. Chair, I'll make a motion to approve the consent agenda as presented.
Second.
Okay, we have a motion and a second to approve the consent agenda. Is there further discussion? Seeing none, all those in favor indicate by saying aye.
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 Any opposed? Consent agenda is approved. We now can have discussion around we have two recommended orders before us today. And Commissioner Messner, I'll call on you for your question around the recommended order.
Thank you, Mr. Chair. And so this is, these are questions specific to docket number, to the extraction enforcement order. I understand that it's been consolidated. I do have some concerns about the volume of NOAVs that are associated with this and the volume of NOAVs that I've seen as a commissioner from extraction, particularly in lieu of not only offering extraction a 35% settlement discount in this particular case, but an additional $40,000 settlement discount if I'm reading the table that was provided in and above the 35% total discount. 35% total discount, if my math is correct, is about $334,751, and then an additional around approximate $40,000 settlement discount inside of the table. I appreciate the public project. I think that's a valuable way to approach violations. But this commissioner would prefer to see no settlement discount except for the $40-ish thousand that was associated at the table, but not a 35% additional settlement discount, but rather see that money, that $334,751 go into the public project in addition to the $521,681 that was proposed in the AOC.
Okay, commissioners, at this point, I would turn to AAG Davenport. What is our process if one or more commissioners desires to not allow a recommended order to become approved because we don't act upon it? Can one commissioner pull it? Do we pull it and set it up for hearing? Do we allow other commissioners to talk at this point? Do we allow Mr. Thomas, who authored the proposed order, to comment? What's our next step? We've not had a recommended order with questions from commissioners.
Thank you, Mr. Chair. Commissioners, unlike the consent agenda, we do need a commission motion and vote to take action in regard to a recommended order. So if you recall our discussion from last week, any single commissioner can pull a matter from the consent agenda for discussion. We don't have the same process for recommended orders. So whatever you do will require a commission motion and vote. You essentially have two options, and I'm referring to, for commissioners and everyone else, Rule 523D1, and that's subpart big letter D within that. You may stay a recommended order, which means it does not become an order of the commission until something further happens. And then you have two options. You can remand the matter to the director for further proceedings, or you can direct the parties to appear before the commission for a hearing. Now, one caveat there, that doesn't prevent you from asking questions of anyone now, the hearing officer, staff, or the operator, if you need clarification. If after asking those questions, you are still unsatisfied and would like to see something change in that AOC, then you can remand it back to the director, effectively for the parties, staff, and the operator to renegotiate and see if they can enter into an AOC that comports with your direction. And if you choose that action, I do recommend that you provide staff and the operator with some direction, as Commissioner Messner has already done, about what changes you'd like to see in the AOC. Of course, if the parties, staff, and the operator are not able to come to an agreement, then pursuant to your instruction, it will come before you as a contested enforcement hearing.
Okay, so let me suggest this. We've heard from Commissioner Messner with regard to concerns. I would like to hear from the attorney for extraction as well as our enforcement officer attorney so that they could provide us with response to Commissioner Messner's concerns. But before we do that, let me ask my fellow commissioners if anyone else has the same concerns or other concerns, so that when we do hear from the parties, they would be addressing the sum total of all concerns. Commissioner McGowan, Commissioner Najapa, in that order.
Thank you, Mr. Chair. I think AAG Davenport, I think I just need a clarification. I think what you're saying is, if we're not going to vote in support of the recommended order and that gets passed today, we can't just amend it on the fly during this hearing. It would come back to us for discussion and any changes that we're thinking we might want. Is that what you're saying? Like, sorry, could you clarify that for me, please?
Yes, Commissioner McGowan, I appreciate the opportunity to clarify. If both parties today were willing to amend the AOC as the commission would like to see it amended, it could be amended today and then go to approval. If either party said, we're going to need some time and go back and see if we can resolve this between ourselves and come to you with a new AOC, then that's okay too. You could make a motion and send it back to the parties to see if they can renegotiate pursuant to what you would be willing to approve potentially.
Okay.
Thank you.
Commissioner Najapa.
Thank you, Mr. Chair. With respect to your question about, whether people had similar concerns, I did have similar concerns regarding the number of violations that were being consolidated. And yeah, I still struggle a little bit with the ways in which we calculate our sort of discounts and determine those things, but also agree that the public project is a valuable one, and would like to see as much of the penalty going towards that rather than in discounts.
Commissioner Messner.
Thank you, Mr. Chair. And just to clarify, if we're having parties present, beyond what I've already indicated in there, which has to do with the volume and severity of some of the violations that are in this particular recommended order, and also understanding that as I've been sitting as a commissioner, I've seen a number of violations from the same operator. I do have questions around at what point do we start to see a pattern of violation from this particular operator, and how that gets considered or addressed by staff. I'm not suggesting in this particular instance that we implement classification of a pattern of violation. But to me, to this commissioner, this particular operator is pushing very close to patterns of violation.
Other comments from commissioners before we hear from the parties? All right, seeing none, Ms. Ryan, I would call upon you as attorney for extraction, if you'd like to respond to the comments made by commissioners. And then we would also hear from Enforcement Officer Stephen Kirschner, so that we've got both perspectives, and then we can see where we are with regard to this.
Thank you. Good morning, commissioners. My name is Julia Ryan. I'm with Brownstein Hyatt Farber Schreck, appearing today on behalf of Extraction. I'll first address Messner's concerns about what is perceived as perhaps a higher volume of NOAVs, and then I'd like to address the discount and the special circumstances surrounding that. So for this, I want to point out that though it may look like there are several NOAVs, that the conduct was spread out over a period of time. These NOAVs range from conduct from 2018 through 2020, and there are 7 in total. So only 7, and many of these were things that Extraction self-reported, things that it recognized were out of compliance with the rules. And so it immediately reported these things to COGCC. In other instances where it was COGCC who caught the non-compliance, Extraction similarly rectified the situation immediately. It either corrected the problem in many cases the next day, and that's reflected in the AOC. For example, when there was paperwork, just a Scrivener's error, Extraction received the warning letter, and then the very next day corrected that issue. And then if there was a type of issue that may have had multiple solutions, Extraction immediately contacted COGC staff to work through a resolution that was satisfactory to the COGCC. Also, none of these violations were major violations. The majority were minor, with a few in the moderate category. Although they were moderate, they were classified as moderate because they had the potential a threat of impacts, but there were no impacts. And that's something that staff has agreed with. And there were no health and safety impacts for any of these violations. And again, many of these were paperwork or other things that perhaps involve delays outside of Extraction's control. And Extraction is very much committed to health and safety and improving its compliance. And so as a result of its NOAVs, Extraction has instituted new standard operating procedures and instituted other internal checks and balances to ensure that these problems won't occur again. I can stop there and see if there are more questions on that piece, or I can talk about the bankruptcy discount if you would like.
Why don't you go ahead and speak to the bankruptcy discount, and then we'll have questions once you're through with both presentations.
Sure. So I'm not a bankruptcy attorney or a bankruptcy expert, but I work closely with Extraction's outside bankruptcy counsel throughout this process. And all of the conduct involved in the NOAVs was pre-petition conduct, meaning activities that occurred before Extraction filed for a reorganization bankruptcy. So in a bankruptcy, a company has an obligation to protect its secured creditors and to take certain actions to protect its assets. Basically, a company has restrictions on what it can spend or agree to spend during bankruptcy. Often these expenses need to be approved through bankruptcy court. And bankruptcy counsel was firm in their position that the penalty amounts qualify as unsecured pre-petition claims. And the COGCC was aware of the bankruptcy and never made a claim for these penalty amounts in bankruptcy court. And so Extraction's bankruptcy counsel advised that the commission would only be able to receive at most 17% of the assessed penalty, and that amount would actually be exclusively payable in Extraction's common stock, because that's what all unsecured creditors received. So if that would have happened, the commission would have only ended up with a little over $16,000. And again, that would have been an extraction stock. So the proposal before you instead gives the COGCC a penalty of well over $500,000, and extraction will be helping to reduce the state's orphan well inventory. So extraction offered to pay more than what the COGCC would have otherwise received if this was dealt through bankruptcy court. And this 35% figure is what bankruptcy counsel thought was more than reasonable given these very unique circumstances.
Sorry, I couldn't unmute myself quick enough. Mr. Kirschner, we'd like to hear from you now.
Sure. Commissioner Robbins, can you hear me?
Yes, we can.
Thank you. I would echo what Ms. Ryan said. I'd also like to give just a little bit more context behind this settlement and why it looks the way it does. I appreciate the concern that I'm going to first address sort of the amount of NOAVs and the volume of the settlement here. I appreciate the concern about that. This matter began over a year ago when Ms. Ryan and I were discussing one of the NOAVs contained herein. Extraction, and I don't want to get too deep into the negotiations behind this, but I will say that Extraction approached the commission about trying to achieve sort of a clean slate compliance-wise. They approached us about seeing what was out there, trying to resolve those issues, and trying to resolve everything at once. As you know, we have a resource backlog. We have a number of NOAVs in our backlog. The amount of NOAVs you see here is frankly not unusual for an operator the size of Extraction. Extraction merely approached us and asked us about resolving things kind of as a group. Based on our resource issues and based partly on the fact that Extraction over the last 2 years has markedly improved in their compliance activities, we elected to pursue that. And this was before we knew about the bankruptcy. So over much of 2020, Ms. Ryan and I went back and forth discussing the NOAVs, discussing what we'd be able to resolve and what that resolution would look like. We then found out Extraction would be going through bankruptcy. And Ms. Ryan and I continued to negotiate during those bankruptcy proceedings. At some point, we arrived on the total penalty amount figure. And as Ms. Ryan said, they discussed it with their bankruptcy counsel. And we discussed it very seriously with our own bankruptcy counsel at the AG's office. I want to note that we don't necessarily agree with the characterization, but our bankruptcy counsel was concerned enough about the risk of potentially litigating this matter in an out-of-state court that they felt like the 35% figure here was appropriate given the totality of the circumstances, especially that we simply don't know the outcome of what such a litigation would be. And there is a real chance that we could have ended up in the situation Ms. Ryan describes, where we would have found to be an unsecured creditor and we would have had the recovery that she described. So given the very real potential for that, our bankruptcy counsel felt like that 35% settlement discount was an appropriate figure here. I would also add that staff felt like that 35% discount was appropriate. As I noted earlier, Extraction has been markedly improved in its compliance activities over the last couple of years. I've seen that through my work, and I've heard that from our on-the-ground field staff as well. In a number of situations, the NOAVs that you see in front of you lag, and while Extraction has had a number of NOAVs in front of the commission, I would put forth today that their compliance activities have improved. Does that mean they're going to continue to improve? I don't know, I can't tell you. But what I can tell you is that in discussing these matters with staff, we've been satisfied with the way Extraction is approaching compliance in the lead up to this settlement. The volume here is simply because this was negotiated as a complete resolution of Extraction's outstanding compliance issues. It's not unusual for an operator of this size to have 7 NOAVs. It's not unusual at all. So given those circumstances, we felt like the 35% was appropriate. I want to stress this as well because we discussed this with the hearing officer during the review hearing, and he's correct in his concern. I think you're correct in your concern, Commissioner Messner, and I want to note that I'm not entirely comfortable with a settlement discount of this size. This is an extremely unusual circumstance, and more importantly, this is an extremely unique circumstance. This is not a discount we will offer to other operators. This is not a discount we plan to offer in other circumstances. The individual circumstances behind this settlement led to that discount. we're putting in front of you because we believe it's appropriate given these circumstances after consultation with the AG's office. So that's where we are on settlement discounts. Regarding the 40,000, I think we tried to explain that specifically in the, I think you're talking about the one related to the McGurr. We did offer adjustments to penalty amounts based on the fact that some of the compliance dates and some of the dates for which extraction was out of compliance were a result of agreed upon delays by extraction and the surface owners to complete certain work at those sites. We felt like it wasn't necessarily equitable to assess a penalty for days of violation that existed due to an agreed upon circumstance between extraction and the surface owner. So based on that, we felt like it was appropriate. Everything else you'll see is purely based on mitigating factors that are laid out in our rules and in our enforcement guidance and penalty policy. And to kind of sum it up, you know, the most important thing I want to stress here is that this is a very unique settlement that you have in front of you today. It was arrived at through approximately a year of negotiations between staff and extraction with heavy consultation from our bankruptcy counsel. We do believe it's the right thing to do, and we want to make sure that you know, we're answering your questions to the best of our ability, but we do believe that, as the hearing officer believed, that the settlement is appropriate given these extremely unique circumstances.
Thank you, Mr. Kirschner, for staff's presentation. Commissioner Messner, Commissioner Nanjapa, or our other commissioners, do you have any response questions for the panel that's before us now? Commissioner Messner.
Thank you, Mr. Chair. That context is helpful. I think that context would be helpful to have in that recommended order, because it was not clear in the recommended order that that was the context or the situation. And I think if we're writing recommended orders that we're supposed to be approving, then having that context is important to have in there. It is unfortunate and frustrating for this commissioner to see an operator utilize bankruptcy, you know, as a way of shedding liabilities. And this is a liability that this operator has created for itself by its operating practices. I understand that in a contested hearing, the chance of recovering even what the suggested amount is in the recommended order may be problematic. I also think that an upstanding operator that is taking responsibility for its liabilities even outside of bankruptcy should understand that the full liability is the responsibility of the operator, and not negotiate a 35% settlement discount in this particular situation, but to take responsibility for their actions and participate fully in the resolution of those liabilities that they created for themselves. So I still struggle with this particular situation. I appreciate the fact that the operator over the last couple of years is improving, but the track record that I've seen as a commissioner, and I've only been a commissioner 2.5 years, and I understand that this is stuff that, you know, maybe is a year or two lagging behind, but has not been particularly good from an NOHB standard. And it's not just a paperwork issue, but failed mechanical integrity tests, failed reporting of mechanical integrity tests, and things of that nature to me are not paperwork issues, but real life public health, safety, welfare situations. And so having said that, I do struggle with this particular one, and I do hope that this is a special circumstance. I'm not sure what the resolution could be, besides for the operator to take full responsibility for their liabilities.
Other comments from commissioners? Commissioner Nanjapa.
Thank you, Mr. Chair. I really don't have anything to add. I really appreciate Commissioner Messner's comments and all of the remarks. I also appreciate the additional information from Ms. Ryan and Mr. Kirschner. That was very helpful. And yeah, just concur on as much of that type of information being available to us in the orders going forward.
And I echo all of that. And I'll leave it to Mr. Kirschner and our officers in terms of, even if you don't put that kind of additional information in an order, if you were to have kind of a summary document that is alongside the recommended order to provide that additional context and perspective, I think that would be helpful for commissioners as we see and hear additional recommended orders moving forward. So I'll leave it to you to sort of figure out what's appropriate for an order versus what's appropriate for some sort of summary document that both parties can agree on. That would help, I think, is what I'm hearing from my fellow commissioners. Okay, so with that, I believe we need to make a determination. Do we have, so we can do one of two things. We can allow this to remain as a recommended order and do nothing, in which case it becomes an order of commission, or we can entertain a motion to remand this to staff for further consideration in accord with the direction that you've heard from us. Or I guess thirdly, we could ask that this come before us as a contested matter. Are those our options, AG Davenport?
Yes, Mr. Chair, that's a good summary of what your options are. The one thing I'll add is if the commission does choose to remand this back to the director to, there has been some discussion, and I think it's relatively clear what the commission's direction is, but to be clear on that motion, why you're remanding it, what changes are important to you to see. And just to reiterate, since this is a settlement agreement we're effectively talking about, it's possible that the parties may not be able to come to an agreement around pursuant to your direction, in which case it would come to you as a contested enforcement matter.
And again, from a settlement perspective, thinking back to my days as a lawyer before I was director and commissioner chair, parties can agree to things in settlement that they don't necessarily would agree to if it is a contested matter. In other words, the public project component of this, which I think we all see as positive, that's before us because volitionally the operator and our staff have come to that agreement. If we force this into a contested matter, it's just a matter of dollars and cents, right?
Mr. Chair, yes, I think that's a question to me. Yes.
Sorry.
AG Davenport, yes, you're correct, Chair. The public project, one of the elements of a public project is it's something that the operator is not legally obligated to do otherwise. So if it did come before you as a contested hearing, it would really essentially boil down to what is the penalty amount and your conclusions finding violations of specific rules.
Okay. With that, and with all things considered, I'll put my 2 cents out. I agree with the points that Commissioner Messner and Commissioner Nanjaba have made. I agree with the point that using bankruptcy as a shield for obligations is not something that is appropriate. You ought to be responsible for your actions and activities. Having said all of that, I believe that the weighing the balance of all this, the sum total for the public good is that this recommended order is appropriate given the very exceptional circumstances that we're dealing with. And so I would be in favor of allowing the recommended order to move forward. But that's just me talking. I definitely want to hear from my fellow commissioners. Commissioner McGowan.
Thank you, Mr. Chair. And I agree with everything that's been said thus far. And I think I'm supportive of moving forward with the recommendation. Sorry. I think that staff has done their due diligence, and I think that they've come to probably the best place we're going to get versus trying to take someone to court and get more through some sort of a bankruptcy hearing and the time and effort it would take staff to do that and try to get something more, I think is not worth the benefit of what they've come to an agreement with Extraction. But I agree with Commissioner Messner, it's a lot of violations all lumped together and you get to see them, and it just raises some concerns as a commissioner, and hopefully we're going to see better compliance. Mr. Chair, I think you had two commissioners raise their hands while you were.
Yeah, someone else can allow other commissioners. My internet is unstable. I apologize.
Mr. Chair, I'll make a quick comment.
Thank you.
Yeah, I'm comfortable with all the work that's gone into this negotiation between the enforcement staff and the operator. It is a lot of violations, and I do appreciate the operator looking for an opportunity to have kind of a clean slate compliance and to identify all the outstanding issues and move forward in that direction. I share the same concerns as Commissioner Messner and Commissioner Nanjapa. Using bankruptcy as a leverage to negotiate down with is well within the operator's purview, but I don't think it's the right way of going about business, and hopefully we don't see this much of that going forward. So that being said, I'm comfortable moving forward with the order that that's been negotiated by staff and has been recommended by staff.
Okay, I think my internet is back. Is there other commissioners? Raise your hand if you want to speak. Commissioner Messner.
Thank you, Mr. Chair. While I acknowledge the public benefit that's been indicated here by the other commissioners, and I'm still looking at the Operators Council, because I think there's an opportunity here to actually make an adjustment to this and take responsibility for their liability without having to remand it back to staff. I also acknowledge that it appears that the majority of the commission appears to be okay with the recommended order as presented. I still think it's an inappropriate settlement and encourages the utilization of bankruptcy to shed liabilities by operators, and that's not something that I'm comfortable with. So those are my final thoughts.
Anyone else with final thoughts? All right, seeing none, I believe we have a majority that are in favor of leaving it as is, in which case we would do
Mr.
nothing.
Chair, it appears that Ms. Ryan has her hand raised.
Oh, Ms. Ryan.
Thank you very much. I just wanted to make one final responsive comment, please. And again, I appreciate all of your comments very much. And Extraction is committed to continuing its improved compliance trends. And we're really confident that some of the lessons learned from these NOAVs are being put into good action moving forward. I just want to make a quick comment for the record about the use of the word liabilities, because that to the public may suggest that Extraction didn't perform some work it was required to do under the commission rules. So I just wanted to clarify that penalties are always discretionary, so they become liabilities as they are assessed. But Extraction is not discarding or evading any liabilities in terms of performing corrective actions or getting all locations back into compliance with the rules. It has done that. So I encourage the commissioners to adopt the recommended order, but if not, Extraction would need some time because we'd be looking for a bankruptcy court to weigh in on how this matter should be resolved. Thank you.
Thank you, Ms. Ryan. So AAG Davenport, at this point, I believe there's a majority to accept the recommended order, which means we take no action. Maybe what I should do is see if there's a motion to not adopt the recommended orders. I'm just trying to give everybody a chance to say there's peace, and I'm not sure exactly how to do it. I apologize.
Thank you, Mr. Chair. You've accurately summarized it. If any commissioner can certainly make a motion to take action on this AOC, the motion would need to pass by majority vote for that action to be taken. If it does not pass, then and no other motions are made, then the commission can simply move on to the next agenda item, and the AOC will become an order of the commission.
Okay, so does any commissioner desire to take a motion, to make a motion on either of the recommended orders at this time? Okay, I'm not seeing any motions. We will then move on. The recommended orders will become orders of the commissions. This one has an asterisk. That is the points made by commissioners, but it will move on as a recommended order that will be an order of the commission. Thank you, Ms. Ryan. Thank you, Mr. Kirshner, for both appearing with us today and providing this additional perspective. With that, we would move to commissioner comments, which is the last item on our agenda for the day. Does any commissioner have comments for the good of the cause? Commissioner Najapa.
Thank you, Mr. Chair. I didn't earlier comment, but I just wanted to thank both my fellow commissioners and as well as Great Western for presenting the additional information on the wells and the status. And I guess I would also say, if that is possible, to provide that level of detail as well in the consent agenda materials that we receive, so that we have a better understanding of you know, the current status of you know, wells that are being reported as within an application area. That would be really helpful as well. But you know, that aided a lot for me in terms of understanding kind of what we were doing in relation to these other wells, and better understanding the status of those other wells in close proximity. But again, I just appreciate the additional information that was shared today.
Good point. Thank you, Commissioner Najapa. And, you know, without asking staff to sort of think, you know, get into our heads about what we might have questions about, I think the staff clarification memo or staff memo that could be an additional document, just as it could have been an additional document for the recommended order that could do the same thing for the consent agenda. So we'll continue to sort of parse through how best to do this, but I think those are good comments. Additional comments for commissioners before we adjourn? Seeing no further comments, do we have a motion to adjourn?
So moved.
Second.
We've had Commissioner Gonzalez move to adjourn, Commissioner McGowan seconded. All those in favor signify by saying aye.
Aye.
Aye. Great. Thanks, everybody, for being with us. Thanks for the public comment. The commission's meeting on July 28th is now adjourned. We'll see you soon.